just briefly, if I could go through a little bit of background on WIPO, the World Intellectual Property Organization. WIPO is an intergovernmental organization with 184 member states, and WIPO is dedicated to the promotion of balanced and accessible intellectual property systems. And WIPO has been addressing IP questions raised by the DNS since 1998, most prominently with the first WIPO domain name report, which led to the adoption by ICANN of the UDRP. And adopted in 2001, the joint recommendation concerning provisions on the protection of marks and other industrial property rights and signs on the internet, which was the backdrop for several of the proposals, the pre-delegation as well as the post-delegation proposals, which I will discuss later on. And in 2005, upon request of ICANN, WIPO produced a report on new generic top-to-level domains titled Intellectual Property Considerations, which recommended, amongst other things, that gTLDs be rolled out in a controlled manner in the future. Just briefly, a little bit of background on the WIPO Arbitration and Mediation Center, this section within WIPO, which deals primarily with domain name activities. There are several sections within the center which deal with arbitrations and mediations of various IP and technical and business matters. And within that also there is the domain name section, which works on policy development for UDRP registry-specific policies. For instance, the center administers disputes for 58 ccTLDs and works closely with those registry operators to develop processes that either parallel or slightly adapt the UDRP itself. The center, since its initiation, has administered over 15,500 UDRP cases, as well as additional 15,000 cases under registry-specific policies, for instance, the .biz stop policy, the .info sunrise, and the .name ERDRP, as well as .mobi sunrise and premium name trademark application rules. Concerning specifically the ICANN new gTLD program, the position of WIPO has been that while it presents many business opportunities, it also presents legal as well as practical challenges, which is what we're in the midst of looking at the moment. In its press release of March 16, 2009, WIPO stated that this is a watershed moment in the development of the DNS and is of genuine concern for trademark holders. And I would add to that to legitimate domain name registrants as well. And the concerns that were broadly shared and expressed by WIPO have also been voiced by ICANN constituents such as the GAC in their principles regarding new gTLDs as early as March 2007, as well as ongoing discussions within the GAC. And I think just to underscore what was said earlier by the members of the IRT, a lot of what we have been looking at in terms of the new gTLD expansion and the role trademark protection plays in that is at the core. Trademark abuse leads to consumer confusion and a general undermining of the public trust in the DNS. And I think from the perspective both of brand owners as well as legitimate registrants and all stakeholders within the DNS, that's something that ought to be avoided to the extent possible. So just a brief chart from the WIPO press release from earlier this year. As you can see, owing to the .com boom, there was a slight dip in domain name filings under the UDRP with WIPO in 2002 and 3, with an ongoing increase on the average of about 7 or 8% from years from 2004 on, and that was further reflected in filing rates from 2008. Concerning the areas of WIPO UDRP complainant activity, one of the primary sectors that's affected by cyber squatting is the pharmaceutical and biotech industry. And in a couple of later slides, I'll show just a brief breakdown of some of the quotes that UDRP panelists have seen fit to put into decisions, as well as just a brief screenshot of some of the domain names that are used to infringe on brands in the pharmaceutical industry. One recent example is Tamiflu with the recent H1N1 or swine flu proliferation. There were a number of domain names that the center observed in filings, as well as just in news stories that sought to trade off of various pharmaceuticals that were targeting solutions to that problem. Some of the language that panelists have put into cases, I think, is a good illustration of the consumer protection bend on the UDRP cases and trademark protection in the DNS generally, specifically with regard to consumer confidence in pharmaceuticals. One panelist, as recently as 2008, noted that an online site using a cyber-squatted domain name was housing an online pharmacy which allowed consumers to buy counterfeit products and placebo products. So obviously where these types of things are happening, it has a general negative effect on the consumers in general and brand owners in particular. I'll skip just to the last one here. You can read these for yourself, and the full text of the decisions is, as always, available on the center's website at the link there on the bottom of the screen. One of the panelists in a case in 2004 noted that the products sold on the respondents' websites were illegally and potentially dangerous. So I think that just underscores where a panel is making note of that in decision, the seriousness that some of these consumer protection issues can have. This is just a brief screenshot of one brand owner, Hoffman LaRoche. We have on the center's website the search function for parties to search by domain industry or complainant or respondent, excuse me. And so this is just a brief screenshot of some of the infringements that one company in particular faced. So moving on to, from the background of consumer protection and trademark protection in the new gTLD program, the WIPO Center's proposals and its comments consist primarily of the following: the trademark-based pre-delegation dispute resolution procedure for new gTLD registries, which, as the next slide will show, is reflected in the versions of the draft applicant guidebook and was based on a joint recommendation from the WIPO member states. The trademark-based post-delegation dispute resolution procedure for new gTLD registries, which we have proposed this dispute resolution mechanism specifically with an eye towards post-delegation disputes for new gTLD registries. However, given our observed conduct of some of the registrars in the existing namespace and the uncertainty as to how the registry and registrar separation will look in the new gTLD context, we've recently suggested that an appropriate similar mechanism would work for registrars possibly in the new gTLD context. Additionally, we have proposed a discussion draft, and it's very much a discussion draft. We have not fleshed out what would be the specific procedures or standards for what we're calling an expedited suspension mechanism, which dovetails highly on the URS as proposed by the IRT. And so what this would do would be to, in as sort of a complement to the UDRP, would provide brand owners to take down what they believe to be infringing domain names on a more expedited basis. And also the center has published on its website comments to the IRT draft and final reports. So moving to the pre-delegation dispute resolution procedure, which, as I mentioned, was published in draft applicant guidebooks 1 and 2. The WIPO Center responded early in 2008 to ICANN's request for expressions of interest from potential dispute resolution service providers for the new gTLD program. And working with the ICANN staff in the development of the substantive criteria for the legal rights objection procedure, which, like I mentioned, took into account the WIPO joint recommendation concerning provisions on the protection of marks and other industrial property rights and signs on the internet, developed that, and that has found its way into DAG 1 and 2. The WIPO Center has also accepted to administer disputes that would be filed under the LRO procedure and is working with ICANN staff to publish the proposed supplemental rules that the center would work under for public comment under the LRO procedures. Now moving to the post-delegation dispute resolution procedure, what we felt was basically that for rights protection mechanisms such as the URS, the IP claim service, the ESM, whatever types of rights protection mechanisms take place, which those in fact are driven from, I believe it's section 2.7 of the draft base agreement that's in the current version of the draft applicant guidebook, which requires that registry operators have in place rights protection mechanisms to avoid infringements in their namespace. The WIPO Center published its proposal for a permanent administrative option, which would allow trademark owners to file a complaint with ICANN where the registry's actual manner of operation or use is alleged to cause or materially contribute to trademark abuse. And I would just underscore the point made by Jeff earlier that this is something that's not seen to be on the level of the UDRP or the URS. This is something that I believe in one of our proposal documents we've suggested that it would be something akin to a traditional arbitration, although not binding under the New York Convention. So it would be something that's a much heavier process. I think that's reflected in the fees for one, so that this would be not where aggressive trademark owners see what they believe to be infringements in a registry operator space, but where there is systemic and widespread cyber squatting. For instance, some of you might be aware of several cases brought by brand owners where there were trademark infringements alleged on the order of as many as 8,000, which were facilitated by a particular registrar. So that's really the type of conduct that this post-delegation procedure had specifically in mind when it was proposed, as well as being really the glue that held together the other rights protection mechanisms. So in order to give meaning to the RPMs under the new gTLD program, this is sort of the background for that. So ICANN has confirmed the availability of such a trademark-based post-delegation dispute mechanism in its new gTLD program explanatory memorandum on the protection of rights of others in new gTLDs in October of 2008. So on February 5th, 2009, following on that, the WIPO Center communicated and published on its website as well as on the ICANN site its substantive proposal for this trademark-based post-delegation dispute resolution procedure for new gTLD registries. And this is, like I said, intended to be a form of standardized assistance to ICANN's own contractual compliance responsibilities. It's not intended to supplement this or displace this. The way the procedure was suggested both in the WIPO Center's proposal and I think in the IRT report were that where such large-scale systemic abuses were alleged, the trademark owner could bring this to ICANN's attention for its own investigation, and that the trademark owner would have the opportunity to participate, to provide evidence, and if the action by ICANN was not to the trademark owner's satisfaction, there might be a separate ability for the trademark owner to initiate a parallel track. But at first instance, this was very much intended to be simply assistance to ICANN's own compliance responsibilities. And the criteria for the post-delegation dispute resolution procedure build on the pre-delegation legal rights objection criteria, as well as the consideration factors themselves, building on existing UDRP jurisprudence and accepted principles of law. And I think one thing that's clear in the IRT report was that, for instance, where there were specific substantive factors which might illustrate bad faith, there's room for fleshing those out, and that's something that the center looks forward to working with members of the IRT and ICANN staff on doing in the future. So just to sort of go back over what was said before, I think this confirms what was said by members of the IRT, that basically this trademark post-delegation dispute resolution procedure would be intended to capture the most egregious types of systemic cyber squatting in a domain space where, for instance, you have an example, the Apple example, where the representations would be made that the namespace would be used for a certain context, and that would not happen for whatever reason. Maybe there's marketing or active promotion of the namespace for use inconsistent with the representations and warranties made in the application. So where that were the case and where that led to the registry operator itself causing or materially contributing to systemic cyber squatting, that's one instance where a brand owner would have the availability of the post-delegation procedure. Another thing that was in mind when the proposal was being worked on was that where the TLD operator would not only actively participate in the cyber squatting itself, but where it would turn a blind eye to systemic cyber squatting. So this is not something where, for instance, a registry operator would have a cease and desist letter from a trademark owner that there was an infringement in its namespace for one domain name. Again, this is really intended to capture systemic cyber squatting, for example, on the order in the case that's been filed by a brand owner in U.S. court on the order of thousands of domain names. That's not a hard and fast number, but just to give an example of the types of conduct that would fall into this category, where the registry operator itself would be aware of such conduct but not actively doing anything to prevent such conduct. And I think that really reflects, again, the statement in the base agreement that the registry operator would have in place sufficient rights protection mechanisms. So like the members of the IRT mentioned, when there would be a breach by the registry operator of its own rights protection mechanisms or whatever RPMs were implemented across the board, that would be the type of conduct that could permit a trademark owner to bring a case under this post-delegation procedure. And like I mentioned just a bit earlier, given that there is a perceived convergence at the present with respect to the registry and registrar and even sometimes registrant roles, within the current DNS, and given that that could be expanded in the new gTLD program, for instance, where you would have a registry operator who would have a namespace for its clients or its own employees, there would be sort of blended roles there. So given that it's uncertain how that will take shape, the WIPO Center has proposed that this post-delegation procedure could equally apply with some modifications to registrar conduct. And I think just to underscore this, the WIPO Center published on April 2009 its observations, as well as the observations of numerous other individuals and companies on the conduct of one particular registrar, and it was alleged in several of the cases that were cited in that letter that this particular registrar was actively promoting UDRP evasion services and engaged in contributory cyber squatting itself. So moving on to the discussion draft of the expedited domain name suspension mechanism. This was a concept that was communicated to ICANN on April 3rd, 2009, and what this was intended to do was to present options for brand owners to combat cyber squatting in a cost and time effective manner. The UDRP is frequently used by brand owners. There are some concerns that this is not always responsive to large-scale cyber squatting. So for instance, where you would have cyber squatting on the order of thousands of infringing domain names, this was seen as an option for trademark owners to have a mechanism to go after those sorts of infringements of their brands without having the time and expense of a UDRP case in every instance. And this was very much intended to be a narrowly tailored complement to the UDRP. In the WIPO Center's discussion draft, we did not go into what would be the exact relationship between the URS and UDRP, but left it for further discussion depending on what type of model the suspension mechanism would take for instance, depending on whether there would be a need for a panel review or whether it could be based, which was sort of the background of the WIPO Center's proposal, on the observed 70% default rate in UDRP cases, in which case it's not entirely clear that a panel review would always be appropriate. So depending on how it ultimately looked in terms of panel review, substantive review, there would be certain relationship issues with the UDRP that would need to be addressed. And the WIPO Center's proposal for the suspension mechanism included what we called safety valve mechanism for defaulting respondents, as well as bona fide third parties. So for instance, where a registrant didn't have notice of the suspension proceeding and the name was suspended, whether that was due to technical incapacity or unavailability of email systems, we thought it was appropriate to give those parties, as well as bona fide third parties who might have a legitimate claim to a domain name, an opportunity to, in effect, re-register a domain name that had been previously suspended. Just briefly, I won't go too much into these. These are published on the WIPO Center's website, as well as the IRT comment pages. The WIPO Center submitted comments both to the draft IRT report as well as the final IRT report. And like Kurt mentioned, I think it's important to give credit to the members of the IRT for getting together in a short time frame to really craft what represents, I think, a big step forward in terms of substantive progress, as well as laying good groundwork for rights protection mechanisms aimed at presenting trademark abuse within the new gTLD context. And like I mentioned earlier, we see this as not a final product, but a work in progress, and so we look forward to further discussion with the IRT members, as well as ICANN staff and other DNS stakeholders in all of these regards. Just a few general comments on proposals for trademark protection in the new gTLD program. One thing that was important to emphasize is that where you have systems that will be used across such a broad scale of names, for instance, the IP clearinghouse, that the system design should ultimately take account of operational realities, as well as minimizing the burdens on users and stakeholders. So, for instance, it's been suggested that the IP clearinghouse, the burden for that should not be entirely shouldered by trademark owners, but should be equally apportioned, or fairly apportioned, I should say, between ICANN registries, registrars, brand owners. So with specific respect to the IP clearinghouse, just a few very brief comments. I think it's clear that this is possibly a good uniform standardized type of a database for trademark owners. In that sense, very well responds to the needs of brand owners to be able to provide a sort of a one-stop set of data, as opposed to going and filing with each individual registry or registrar. The only suggestion that the WIPO Center has made in its public comments was that where such a ubiquitous role is envisioned for an IP clearinghouse operator, that would have appropriate safeguards that would be monitored by ICANN. And also that given that there could be different needs within specific registries for rights, for instance, someone who sells only shoes or someone who has trademarks in a certain geographic area, that there might be scope for differentiation of roles within the clearinghouse in terms of database collection and storage on the one hand, and rights validation on the other hand, where there might be particular entities that would be more well suited to verify certain types of data on a real-time basis. And again, as I mentioned earlier, it seemed appropriate to the WIPO Center that the trademark owner should not be asked to shoulder the entire burden of financing the clearinghouse. Just very briefly on the URS, and I'll leave most of this for review of the WIPO Center's comments and review of the IRT report, but just briefly I'll mention that with the WIPO Center's proposal, we did not flesh out whether the suspension mechanism should require a panel appointment in every case, given that it was based primarily on the respondent default rates. So we would just suggest that that could be looked at, whether the URS or the ESM with a panel or without a panel has implications on costs and time. And so that's just something for brand owners to consider what is most responsive to their needs. Also, just briefly on the duration of the proposed remedy of suspension for life of the domain name registration, we've observed in several UDRP cases where the domain names were canceled after the domain is canceled, then it's immediately re-registered. There is software that's automated that picks these things up and puts websites up almost instantaneously. So there was just a note of caution on where the remedy under the URS was for suspension, that that could possibly lead to similar scenarios where you would have re-registered domain names. So that's just one issue to think about in terms of how to best respond to brand owners' needs and also allow for legitimate registrations at the same time. Again, the URS, depending on how the substantive criteria ultimately looked and whether there were a panel appointment, for instance, must interoperate with the UDRP. So for instance, if the UDRP is seen as a sort of an appeal or a parallel process, that will drive that conversation. And also, I think the certain aspects of the URS and the UDRP both, for instance, locking of the domain name, would be just sort of the operational aspects that would be ripe for consulting with the various stakeholders within the DNS on how to best have a seamless integration between any suspension mechanism and the UDRP. And this is just a chart showing a bit of the background on the WIPO Center's suggestion for a default-based model where you have something on the order of 70–75% of cases coming in that, for whatever reason, respondents are not replying to. In those cases, a panel would still be appointed and a decision rendered. So having observed that, it was proposed that in all cases that might not be strictly necessary. With, of course, the important caveat that there would be some sort of a safety valve mechanism to allow non-responding registrants to either claim that they were not provided notice or re-register, given that they could show a bona fide or legitimate use of the domain name. I think I've pretty much hit on all the points on this slide. So I'll turn it over now. If you have further questions, feel free to drop an email to arbor.mail@wipo.int or myself, brian.beckham@wipo.int. And of course, the various proposals and comments that have been discussed are available on the center's website.